This is Matt, your host of the Landlord Advocates, where we help landlords become better landlords. Before we get into the topic of discussion that we have today, you may have noticed I have this hair on top of my head. I finally was able to get my hair cut today, and I never thought a haircut would feel so good. It does. Recently, the New York State Legislature passed a bill that is awaiting Governor CUOMO to approve it, sign it into law. Hopefully, it doesn't get signed into law. This bill is called the Tenant Safe Harbor Act. It affects landlords, it affects tenants. As you can well imagine, the effect on landlords is like a hammer to the head. And we're going to explain how that is now. This Tenant Safe Harbor Act is retroactive from March 7th going forward. It is an act that is basically a county-by-county law. Even though it's a state law, it affects it county by county. And how that is that if the county reaches stage 4 of reopening in New York State and does so successfully, this act perishes in that county. So for some counties that are on stage 2 or stage 3, the life of this act is nearing its end. For some, like on Long Island in New York City, who is opening stage 1 now or very shortly, it is a long way to go. So the amount of rent that protects the tenants under this act from March may go until August, September, October, and maybe even November. Maybe even November for some of the counties here in New York State. Now, as most of the executive orders and the acts, the executive orders of Governor CUOMO, and now the acts passed in the state legislature, all look at the income of the tenant. And the three same variables that seem to play a role in everything is the tenant collecting unemployment? Are they eligible for unemployment? Or the two words that this channel has grown to really dislike is the tenant facing a financial hardship. Those are three factors that the court looks at, that the state looks at when it comes to this bill. There's other factors that they look at as income of the tenant. That would be cash assistance, DSS, or as most of you know, welfare. They look at if the tenant is collecting New York State Disability. Is the tenant collecting SSI? Is the tenant collecting food stamps? Are they on the food stamp program? Are they eligible or are they collecting HEAP benefits, Home Energy Assistance Program? If they're getting all of that, they automatically qualify for the protections that this act affords them. Well, there's a few other things that the state looks at as well. They look at the income prior to COVID-19 of the tenant, the income of the tenant during COVID-19, and then one other one. But when they look at the income prior to, and they're doing the same thing that we talked about in our last video, of the area median income, the rent burden, the loss of income, and they equate all of that, there could be quite a few tenants that could fall under the protection of this act. The other variable of income that the state looks at is liquid assets of the tenant. Is that cars, RVs, motorcycles, trailers? What does that encompass? Those things can be looked at through state records for registrations, license plates, and things of that nature. The other thing that they look at when they look at liquid assets, are they talking about stocks, mutual funds, cash that the tenant may have tucked away in the freezer, under the basement stairs, under the mattress? If they factor that in, do they seriously believe, though, that a tenant is going to say, oh yeah, I got $5,000 under the mattress? Obviously, if a tenant does that, they do not get the protections of this act. Now, another thing about the Tenant Safe Harbor Act is that any proposed legislation, any legislation under consideration by a state legislature, they look at the financial implications of that act, that bill. It could be $100 million, $10 million, $5,000, or it could be none. Well, this Tenant Safe Harbor Act, the state legislature has determined, yes, you guessed it, there are no financial implications to this bill. What were they thinking? No financial implications? Were they not thinking of the landlord? If you equate every dollar owed to the landlord by the tenants that have not paid, every dollar is a financial implication. This Tenant Safe Harbor Act has millions and millions of financial implications to this bill. So yes, it does. Now, with all of that said, you can still take the tenant to court for non-payment of rent. Yes, you can take the tenant to court for non-payment of rent, and if you are successful in court, you will garner a judgment for the back rent that they owe you. Now, you may be saying to yourself, that's pretty good. I'd be happy with that. I'm getting a judgment. Now, you might be saying further, Matt, how is that so bad for us? Where's this hammer upside the head that you're talking about? So far, what you said really hasn't shown us the hammer. Well, here's where the hammer comes in. We said that you can take the tenant to court for non-payment of rent, and we said that if you're successful in court, you will win a judgment for the money owed. But what you will not get is a warrant of eviction. You will not get a possessory judgment against the tenant, meaning that even though you've taken them to court for non-payment of rent, and you've garnered a judgment for the amount of money that they owe you, you will not be able to utilize the office of the sheriff or the marshal to remove the tenants from the property. You will only get a judgment of what they owe you in rent. Now again, members of the state legislature who signed A for this bill, not nay, but A, that you want this bill to pass, you want the governor to sign it into law, what were you thinking? Did you seriously believe that the tenant and the landlord would walk out of court hand in hand, singing kumbaya, after the landlord just acquired a judgment for $4,000, $5,000, $6,000 in rent? Do you think they're going to walk down out of the courtroom, down the stairs, out the door, and say, hey, let's go get a beer somewhere? Or is the landlord going to take his free hand because the other one is holding the hand of the tenant? Do you think he's going to take that free hand and reach into his pocket and hand that tenant an invitation to the landlord's backyard barbecue this weekend? Of course not. Of course not. By a landlord taking the tenant to court for non-payment of rent and only acquiring the judgment, but not the warrant of eviction, will absolutely create an adversarial relationship between the landlord and the tenant. We all know that. We all know that. So now you can say to yourself, well, what are my options, Matt, as far as going to court? If I take them to small claims court, it will be less expensive to get a judgment against them in small claims court. And you're right, it would be. What you can do here in New York State, towns and villages only allow you to sue up to $3,000 of what is owed to you. But you have an option. You can take your claim for up to $5,000 to the city that is in the same county that the town and village is in that the tenant lived in. You would be able to get and hopefully get a judgment for up to $5,000 on what the tenant owes you. But if you take the tenant to court for eviction court or housing court, landlord-tenant court, summary proceeding court, whatever court they call it in your jurisdiction, if you take them to court in the eviction side, the eviction part of the court, the housing part of the court, there is no statutory ceiling in New York State that says the amount that you can sue for is $5,000, $10,000. We have had clients who have won judgments in the amount of $20,000 to $25,000 in back rent. Now, yes, I know what you're thinking. How can they let it get that far behind? It can happen. They've done it. That's a topic for another video to help educate you, the landlord, not to let it get to that point. But right now, we reviewed a few other channels and some posts on Facebook. And the one tenant, or the one landlord in particular, right now, through this duration of time, the tenant has accrued $16,000 in back rent, and she is concerned on what can she do to get this tenant out. And right about now, there's not much can be done in New York State. Our advice would be to take them to eviction court. You'll get the judgment for the amount of money that they owe. Now, if it's only $2,000, $3,000, maybe small claims is the way to go. Now, with all this information that we've just bombarded you with, you may be asking, hey, Matt, what advice can you give us? What should we do right now? What is the best course of action that we can take to help ourselves to get rid of this tenant? Well, first, consult with an attorney in your area who can help you better navigate your way through this process so that the outcome is favorable to you and you'll get what you want. Do that. But our advice here on the Landlord Advocates channel would be to not only take them to eviction court for non-payment of rent, but also serve that tenant a 30, 60, or 90-day notice. Why? If you take them to court for eviction court, they may owe you $10,000, $12,000, $15,000 of rent. You'll get a judgment, hopefully, for the amount of money that they owe you. But when you take them with a 30, 60, or 90-day, you'll be able to acquire the eviction against the tenant, regardless of what money they may owe you. To do both, you'll get what you want. It's just a matter of how long it will take to get what you want. That's it in a nutshell. That is the advice that we can give you here. Again, the Tenant Safe Harbor Act has not yet been signed by the governor as of the production of this video, and we don't think it will be signed. And even if it's not, we still want you to understand that the New York State Legislature has passed this bill. Find out if your legislator, your representative, voted in favor of this bill so that you're aware of it. Because many people don't know how their legislator votes unless the legislator sends you a mail and tells you, this is how I voted for you. Well, if it's a bill that they failed, they may not tell you about it. So find out, look at it, investigate it, and see what you can do. As we've said before, landlords, hit the notification bell for future videos that we have. Hit that subscribe button because we have many more videos to come. We have a lot on the channel now, and we have a lot more to come, a lot more to come. We really appreciate helping you. We love helping you. We are here with you. We're here for you. Remember, when I said, leave those comments below because we do respond. Landlords, until next time, take care.